Mr. Mercer, we'd like to know from you quite how this notification came about and what was the thinking behind it.
Lord, we've looked for that. We have the notification as we quoted in our written case. It came about subsequent to scrutiny and consultation on a draft proposal for the regulation, which was in slightly different terms. So that originally the terms of the draft regulation, which became the regulation we're dealing with, said there would be a single appeal on a point of law and didn't specify the court. That was then subject to consultation of the presiding judge of the family division and the Reunite and various practitioner bodies. And then there was...
Do you mean the president of the family?
I'm sorry, I mean the president.
And do you mean, was the president's International Law Committee, International Family Committee consulted?
They were consulted with, at a later stage. Oh. And just this morning, we've seen a...
No disrespect, Mr. Mercer, but when we asked for the assistance of the department, we were actually looking for information rather than legal argument, because we thought the existing parties were perfectly capable of conducting the legal argument, but we did want to know what had happened.
Well, indeed, my lady, and we've been working on it. It's been quite difficult because the relevant person who handled this, the relevant civil servants who handled this, have all left the employment of the Ministry of Justice since.
But the records are not available readily?
Some of the records are, and some of the records aren't, my lady. They relate to 2004, a period when one was changing over from paper to electronic, and so that the full records are not available. But what we have found is if you lady would just give me a minute.
Mr. Mercer, since you're pausing, you opened by saying the terms of the proposed regulation that became Brussels II, I think you must mean Brussels II revised, referred specifically to a single appeal.
They did.
Do we see that in the bundle?
I have copies of it in court, my lord.
Do we see it in the bundle?
We don't see it in the bundle.
We don't? Well then, speaking for myself, I'd like to see it.
Indeed, my lord. So, my lord, we can hand up the clip, which I circulated to my learned friends first thing this morning, having had the opportunity to review it over the weekend, of the material which led up to the consultation and then scrutiny and the resolution of the House of Commons, which is in that little clip. I have, my instructing sister has brought to court a copy of the later document, which was the minutes, the draft minutes of the Family Justice Council International Family Law Committee, which met on the 8th of November 2004. I don't have copies of that in court. I just have the single copy in court.
Sorry,
but obviously...
Family Justice Council.
Family Justice Council International Family Law Committee, minutes of 8th of November 2004.
Thank you.
Well, it would be helpful to be provided with that.
Absolutely, lady.
So where do we look in the proposal?
So in the proposal, we've numbered the pages. For my own friends, we've just numbered the pages as they were sent around in the PDF. The Commission proposal of 3rd of May 2002 is the first document. Page 3 is draft article...
So I'm so sorry, I have a bundle which begins Commission of the Proposal for a Council Regulation, page 1. Is that the right?
Indeed,
that's the first page?
That's it.
Okay, thank you.
It's first page.
Right, thank you.
And then at the third page, double-sided, Article 39, the judgment on appeal, given on appeal, may be contested only by the proceedings referred to in Annex 3. That adopts the same methodology as had been adopted previously, for example, under 44/2001. There was to be an annex. And then on page 5, the fifth page, page 5, 54 in the original document, the appeals provided for by Article 39 may be brought only, United Kingdom, by a single further appeal on a point of law.
But where did that come from?
That comes from Brussels 2, my Lord.
Quite. I mean, that is simply a reflection that in response to Brussels 2 in 2000, that was the entry we made.
Absolutely, Lord.
And the proposal at that time was simply to repeat it,
To continue.
to continue.
That policy indeed, my Lord.
Yeah.
Yes.
Thank you.
And your Lordships then have the document, the next document in the little clip records various letters from Baroness Scotland, who seems to have been the minister dealing with this matter. So it's on page 8. You'll see a list of bodies consulted. I should say this is in a letter of 30th September 2002. Quite a bit of this consultation was at the early stage on the original Commission proposal. That's why we put that.
Thank you.
But then on page 8, you'll see the list, the President of the Family Division,
Yes, we see that.
practitioner bodies, reunite. Yeah. Then also on the right-hand page, page 9, you'll see there about the fourth paragraph down, the government's continued to consult throughout the negotiations. President of the Family Division, Lord Justice Thorpe, senior practitioners, and reunite been consulted over the principles behind the presidency paper. And then the next, there was an attempt. I mean, we kept this document intact, so one sees the proposal and one sees a presidency proposal. This is not, though, the point at which the change was made, because there was a change, obviously, from the proposal, which had Article 39 with an annex incorporated within the regulation. None of the questions we're dealing with today would be before your Lordships,
Right.
if that was still the case.
Thank you.
We see at page 19... 19.
Yep.
We see there the result of the scrutiny of the original proposal. This is the resolution in the House of Commons at the middle of the page. This House takes note of European Union documents, draft Council regulation concerning jurisdiction recognition and amending regulations and related maintenance. So, Your Lordships have, this is the result of the parliamentary scrutiny which had occurred. So, in essence, the parliamentary system for controlling the exercise of powers under the European Communities Act had been applied at that stage. And then there came a stage, unfortunately, for some reasons which are beyond both myself and my junior, the precise point at which the form changed to Article 34 with 68. Very unusually, it's not on the legislative observatory of the European Union in Eurolex. Normally one can find everything in Eurolex, but we looked yesterday again and we haven't found it.
You mean the change from annex to notification recorded in a separate document?
Absolutely, Lord. That's that
There's
change.
something in the papers, I afraid I forget where, to indicate that this was simply so that when a state wished, for whatever reason, to change its notification, it was less cumbersome if it was all in a separate document than if there was an annex requiring the entire regulation to be amended.
Indeed, my Lord. I'm not sure I remember quite in those terms, but certainly it seems to have been on the basis of...
May I help on that? It's tab 58.
Thank you.
Thank you, Mr.
Page
Turner.
Grateful to my friend.
315
Thank you, Mr. Turner.
It's under list of notified proceedings.
Thank you.
But of course, sometimes changes on grounds of efficiency don't sometimes present problems for us as lawyers. The next stage, so this was at the initial stage,
Sure.
and then the next stage is that the notification took place. That was on the 1st of November 2004. But I've then, and I will ensure that suitably redacted versions of the minutes are supplied, just to cover normally I think I omit the names of the persons involved.
The minutes of which committee?
The minutes of the meeting which I referred to earlier, to my Lord's question, the Monday, the 8th of November 2004, the International Family Law Committee. And that occurred just after the notification, and the discussion in those minutes relates to draft domestic regulations. And we do have those regulations in the bundles.
Right.
And so it's clear from the discussion, as your lordships will see in due course, that certain points are made in relation to those draft regulations. And perhaps it's best just to go to those regulations, which is in tab 28 in volume 1.
Thank you.
I'll go first of all to the explanatory memorandum at the last page.
Tab 28.
28, yes.
Yep.
It's
Explanatory memorandum.
2005 regulation.
Page 7, yep.
So page 7,
Thank you.
the new council regulation is directly effective. This is the second paragraph, I should have said, second paragraph. The new council regulation is directly effective in the United Kingdom, and consequently the changes affected by these regulations are limited to those necessary to amend inconsistent provisions of national law.
Right.
And then I draw your lordship's attention simply to regulation 5, back on page 2 in the regulations, which
2.
assigns business but does not purport to confer jurisdiction. So it assigns business for the first appeal
Yep.
to the family division of the High Court.
Yep.
But neither in respect to the High Court nor the Court of Appeal does one find a provision conferring jurisdiction, because the belief was, both of the those behind me, or certainly their department at the time, and it seems of Parliament, and those consulted, because persons were consulted about these draft regulations, and these regulations were subsequently laid before Parliament on the 9th of February 2005, and came into force on the 1st of March. No one in that process felt that anything more was necessary than the regulation, Articles 34, 68, read in conjunction with the notification which had taken place.
So
That's the answer to your question. As far as we've been able to establish it,
that's as
my
much as you can have been able to find out. Yeah.
indeed, my lady.
So we don't really know how it was decided to notify, other than just doing what had been done before.
And, certainly it's very clear that there was, the consistent policy, we're going right back to 68 Convention, has been a restrictive approach, limiting the number of requirements to which a judgment has been subject. But I've asked that question, asked it again, and discussed it again this morning. We haven't found any specific document, such as a submission to the Minister, setting out the reasons for which this decision was taken.
Would the Minister have been involved?
Well,
Would
it may have been
he or she have had a she? It looks as if it was she.
Well, it may have been a general notification. It may have been a general submission at an earlier stage, at which do we maintain our consistent policy from the 2000 regulation, which is, of course, relatively recent regulation, just 3 years before. Do we maintain our consistent policy? Or it's conceivable that there may have been a separate submission. I think that the feeling was this morning that that was slightly less, the second possibility was less likely. But that's a matter of pure probabilities.
So it may have been general rather than particular. We don't know.
I'm afraid we don't know, lady. But it would be normal that if the policy is being continued, then that is something one would then address specific attention to where a policy was being changed.
Yeah. Thank you. That's Very helpful. It was what we were hoping the Ministry might be able to supply us with. Anything more that the Ministry can supply us with, if it turns up, I think we would be illuminated.
Yep, I've got
Right,
an idea. And we have been looking, and I've been asking exactly those questions. In fact, you reunite. I saw a little checklist of questions for myself to address in this regard. I thought it was rather work to be done. Thank you, Lord.
Thank you very much, Mr. Mercer. Mr. Harrison, we were very grateful for your submissions, and we thought, if I may say so, they were very well presented. And I'm afraid, having thought about it over the adjournment, we remain where we were. Therefore, we needn't call further on Mr. Mercer or on Mr. Harrison or Mr. Turner. Oh, Mr. Turner or Mr. Anderson. I think the correct order is, we think the correct order in those circumstances is, it sounds rather aggressive, but to strike out the appeal. I think if we dismiss it, it indicates we've reached a decision on its merits. If we strike it out, I think that makes it clearer that we haven't reached a decision on its merits. It's right you should know that now because of the imminence of the likely otherwise of the hearing, but we will give our reasons in the normal form later.
Thank you all.
Thank you all very much indeed for producing your written submissions and written cases, and for all those involved in preparing them under considerable time pressure, as they enabled us to form a view and think about this ahead of the case, ahead of the hearing. It speaks for itself that they've been very useful. Thank you all very much indeed. Thank you. Court's now adjourned.